Ladies and gentlemen, welcome back to the IndieZone here on YouTube. My name is Kathy. December 20th is a critically important day to the defense. This is where they get the final word, the final say on their various critical motions that they have filed, seeking to strike warrants, seeking to suppress evidence associated with such warrants as those that were rendered that allowed law enforcement to search and to seize property from his apartment in Pullman, Washington, from Mr. Kohberger's family home in Albrightsville, Pennsylvania, his car, the white Elantra, and other matters. Those are all motions to suppress that he filed, that the state has responded to, and that now Mr. Kohberger will have the last word in the form of a reply that is due December 20th. Just by way of background, a motion is an application for a court order. So when you see Mr. Kohberger filing a motion to suppress evidence or a warrant or for a Franks hearing, he's asking for the court to enter a ruling in the form of an order granting him whatever remedy or relief he's seeking. The other side here, the state of Idaho, has an opportunity to respond and try to persuade the judge, no judge, these warrants were perfectly acceptable. Mr. Kohberger's Fourth Amendment privileges against unreasonable searches and seizures were not violated. Everything was in order. You should deny this motion. That is basically, in a nutshell, what the responses are, because he's opposed. The state has opposed all of Mr. Kohberger's filings. So now, the final word, the third step in the process is a reply. And this is not where Mr. Kohberger gets to re-argue his entire motion again, why he should, for example, be granted a Franks hearing. No, this is simply supposed to be him responding to the state's response. Now coming back and saying, Judge, the state is wrong, and here's why they're wrong. Here's the evidence to counter whatever evidence they're submitting. Here's legal authority showing that they have misinterpreted the law. Things along that nature, strictly related to replying to the response. That is what is due on the 20th of December from Mr. Kohberger. If you have not yet had an opportunity to listen to the episode of the IndieZone that we did a couple of days ago here on YouTube, where we went over the Jerome Franks versus State of Delaware case and provided the test that that case gives for Mr. Kohberger to even be qualified to have a Franks hearing, please do so. There's also a link in the description to that episode of the IndieZone here on YouTube, to the Franks case. It's a very long case, but that will give you an opportunity to read the entire decision for yourself. Just as Mr. Kohberger bears the burden, and it's a high burden for him to even qualify for a Franks hearing, he also has the burden of proof, and it's a high burden to try to get any of these motions to suppress granted. Would like to quote now from one of the state of Idaho's responses to Mr. Kohberger's motions to suppress. They've cited the same case law in various motions to suppress, but I'm going to now read directly from the motion seeking to set aside the warrant for the white Elantra, which the Affidavit of Probable Cause referred to as Suspect Vehicle 1, and what the state had to say in response. Under the section entitled Valid Search Warrant, this is where the state is providing the case law, the legal authority showing that it is not a 50-50 proposition. It's not the state coming in and trying to persuade at 50% possibility versus the defense at 50% possibility whether this warrant was proper or not. No, no, no. It is Mr. Kohberger's burden entirely to persuade Judge Hippler that this warrant was improper, and therefore the warrant should be suppressed and all of the evidence that was obtained from that warrant should be thrown out. We're going to go to page 3 of the state's filing here. It says here that if a search is conducted pursuant to a warrant, the burden of proof is on the defendant, that would be Mr. Kohberger here, to show that the search was invalid. And the state is now citing to a case called State versus Wilson. This is an Idaho appellate court case citing to State versus Kelly, another Idaho appellate case. Next, the state of Idaho says Idaho recognizes the U.S. Supreme Court's analysis and holding that, quote, great deference is paid to the magistrate's determination for probable cause. Great deference means great respect. So that is the starting point for Judge Hippler's analysis as to whether or not to grant a motion to suppress, that the law recognizes that there is great respect or deference paid to the magistrate's determination for probable cause. And here the state of Idaho cites to not just Idaho case law, but also U.S. Supreme Court case law. Spinelli versus U.S., 1969 case. Illinois versus Gates, a 1983 case. And then finally, State versus Josephson, which is an Idaho appellate case standing for the proposition that the state of Idaho recognizes. It believes that the U.S. Supreme Court's analysis of great deference to a magistrate, that is the proper legal standard. So we see here that Mr. Kohberger has the burden of proof, that it's a high burden, that the starting point is that great deference would be paid to whatever magistrate judge signed off on the particular warrant in question. And from there, he needs to provide substantial evidence, and the evidence would be from the discovery responses that Mr. Kohberger has received in this case. Because in discovery, what a party does is they ask the other side to turn over documents, things, video, transcript, and the like that the party believes is in the government's possession that is relevant to the defense of his or her case. And unfortunately, we do not have access to a lot of that evidence because every discovery request dating back to January 2023, all the way down to the latest one, the 20th supplemental discovery request that was just served a couple days ago, are under seal, as are all of the responses. We do have a little bit of information based on what we have learned at hearings on motions to compel, such as the hearing and the order that Judge rendered in October of 2023, granting Mr. Kohberger motion to compel some of, not all, but some of the IgG DNA evidence he was seeking. There's other statements that have been made, for example, in Judge Hippler's November 22nd, 2024 order, where he ordered Mr. Kohberger to resubmit his package seeking a Franks hearing. There is a footnote number 1, and that footnote number 1 is where Judge Hippler describes that what Mr. Kohberger submitted apparently was information regarding the expert's identification, feeling comfortable with the white Elantra being a 2011 to a 2013 Elantra. That was the initial opinion that was given. So that gives us a clue that that may be one of the items that Mr. Kohberger is raising in his motion for a Franks hearing. So we're going to wait for the 20th to see what is filed on that date. Unfortunately, we have no reason to believe that a lot of the information will be under seal, as both the motion for the Franks hearing, the substance of the motion, all of the items that were submitted in the case law was filed under seal, as was the response. So anticipating that a lot of the information will be under seal, but some is not. So we're going to wait to see what the defense files on the 20th and also how the court rules. There's going to be oral argument per the October 9th order on the 23rd of January regarding the motions to suppress and to compel discovery. The court has also set aside an additional day on the 24th if any additional time is needed. This will now conclude this episode of the IndieZone here on YouTube. I want to thank you, as always, for joining us here today.